See you.
All right. Well, why don't we start this thing? Greetings, everybody. Thanks for joining us. My name is Eric Hauge. I'm the Executive Director at Homeland, and you're joining myself and Mike Vra, Homeland's Managing Attorney and Hotline Director, as well as Rachel Sterling, Homeland's COVID-19 Eviction Response Coordinator, Housing Attorney. And you're joining us on Wednesday, February 23rd at 1:30 for another one of our webinars. Just a little bit of background on what Homeline is. We're a statewide nonprofit organization that provides free legal advice to renters throughout the state. And our hotline services are available in English, Spanish, Somali, and Hmong languages. And we also have a staff beyond our hotline, tenant organizers, public policy staff, as well as researchers. There's our hotline number. If you, we are going to be providing general kind of Q&A throughout the day today. Rachel is going to go through an update on the current situation with the eviction moratorium phase out. And then we're going to open it up for Q&A. But if you have if you're a renter and you have a specific question about your legal situation, please do give us a call on our hotline. We'll provide general legal information on the webinar. But if you have a specific legal situation, housing situation, please contact us. We do have a number of resources on our website, information about the eviction moratorium phase out, and I'll send some links in the chat in just a moment. We do not have our next webinar scheduled, but we intend to have these sessions at least probably once a month throughout the rest of this year, and we'll be covering a number of topics as we proceed on this, because there's a number of issues that are popping up in terms of rent control in both Minneapolis and St. Paul, as well as some other local ordinances that are getting passed. So we'll be covering some of those topics over the next few months. So with that, I'm going to hand it over to Rachel, who will provide some guidance on where we are in the eviction moratorium phase out right now.
Thanks, Eric. All right, well, hello all. So first things first, if you've been staying with us through the last, oh gosh, coming up on, closing in on 2 years quickly, then you'll know that these have shifted around a bit, these presentations. And so I think the most important thing right now to know is what this slide tells us, is that Rent Help MN is no longer accepting applications. The program itself is not closed as of yet. They're just not accepting new applications or renewing. If you had an application and then you needed to reapply, they're not able to take those either. As of January 28th, they shut down their application. And so then, excuse me, and so they are processing through those with what they've got. And basically, at this point, they're anticipating that with what they've got in applications, that they are going to run out of the funding that the federal program provided before the, I guess before they run out of applications, probably. So we do have some other programs available, such as the St. Paul Ramsey County Assistance. This one is useful for us because it still is funded by that same federal funding that the Rent Help MN program was, but it is not being processed through the same Rent Help MN program. And so if you are a Ramsey County resident, you can still try and get funding that would fall under the phase out protections. And so I'll get to those more in detail in a minute. Again, if you've been around for a little while, you'll know that what I'm talking about. But essentially, if you are a Ramsey County resident, there may still be funding available that would fall under the phase out protection. I believe at this point they have shut down their website application for maintenance or some sort of update. What they say is that they're implementing changes to increase the efficiency of processing their emergency rental assistance applications, but they are still accepting applications either via phone or in person at one of their service centers. And so that is a possibility, again, if you're a Ramsey County resident. There's also Washington County still has some funds that are from that same federal pool that they are administrating, and those are slightly confusingly, you still apply for those funds through the Rent Help MN portal, but it's not the Rent Help MN program, it's the Washington County program. So again, if you're a Washington County resident, you still have access to some of those funds that would still give you protections under the Minnesota phase out law that's in place. So that leads us very neatly into the phase out overview, which is put together kind of just a quick overview of what still remains of the phase out. For just a quick recap. So back in 2020 through June of 2021, there was an eviction moratorium in place, essentially limiting the evictions that landlords could file to very specific incidences. And then in June of 2021, well, slightly before that, but effective in June 2021, the legislature passed what is called the phase out, the eviction moratorium phase out, which slowly allowed those protections to lapse and for more options for landlords to file evictions or end leases or not renew leases, kind of slowly coming back into play, as it were. And so most of the protections that had been in place through the eviction moratorium were completed or lifted back in October of 2021. So everything is quote unquote essentially back to normal, except for there is still one lingering protection in place for tenants. For those who have a pending application with a specific emergency rental assistance program that was funded through the specific programs that are listed in the session law, the protections, and those are going to be the two federal programs that Congress passed, very creatively called ERA 1 and ERA 2. Those programs that I just mentioned are the Ramsey County and the Washington County that are still available for application. Those tenants who have a pending application with those programs are protected from non-payment of rent evictions through the end of June. So that protection expires June 1st of 2022. So it's also that there is some onus on the tenant to make sure that if they have access to the info that they need to give their landlord or the court proof of their pending application with one of those programs, and if they know any reason for the delay in processing the application. It's exceptionally important that a tenant knows that they have to show up to the Zoom hearing, or it's the court hearing. Most of them are still under Zoom or a virtual hearing. We're getting very few reports that there are some court jurisdictions that are going back to in-person hearings, but very, very limited. But it's really important that a tenant shows up for their initial hearing so that they can tell the court that they've got this pending application, that they are protected under this phase out law. The court isn't going to know if they have one or not unless the tenant shows up. And we've seen far too many evictions happen because the tenant thought that they were protected and so didn't bother showing up, and then got a default judgment against them because the court doesn't know unless you tell them. So again, it's very important that tenants show up to, if their landlord erroneously files an eviction for non-payment when they have a pending application, it's very important to show up to make sure that the court knows they are protected. And then, as any time, tenants should seek legal advice about their situation before they go to their court hearing. So the next slide is what is happening. Oh, no. What is happening with pre-eviction notices? Sorry. Sorry, Eric. So one of the things that was also part of that phase out law was that there was an eviction, pre-eviction notice requirement that was in place. That was one of the things that expired back in October. And so there's no more state level pre-eviction notice requirement, but there are some cities who that are have implemented their own pre-eviction notice requirements. So far, that's St. Louis Park and Minneapolis. Those are for non-payment evictions. St. Louis Park requires a 7-day notice, and Minneapolis requires a 14-day notice. Again, for non-payment evictions. There are still also some federal level pre-filing eviction notice requirements that go with certain types of properties. So one of them is under the CARES Act. So I know that if you remember way back when, the very first set of kind of emergency funding revolving COVID was called the CARES Act, and most of those provisions expired or sunsetted back in 2020. However, there was one term that just never sunsetted and has still yet to sunset. That is the 30-day notice requirement for CARES Act covered properties. Now, figuring out what a CARES Act covered property is not the easiest thing in the world, but there are several sites out there that can help you figure out. But in a nutshell, it's going to be properties that are covered under the Violence Against Women's Act, or VAWA, as well as federally backed mortgages. So like Fannie Mae, Freddie Mac, those sorts of things. But that requires those properties, landlords, if they have those properties, need to give their tenants a 30-day notice, pre-filing notice for non-payment evictions. Kind of on those coattails, there's also the HUD properties. HUD just passed a rule that basically says, similar to the CARES Act, that HUD covered properties need to give a 30-day notice for public housing and project-based rental assistance tenants prior to evictions for non-payment of rent. The notice has to include information about local emergency and rental assistance programs. So that is a slightly different than the CARES Act notice requirement. The CARES Act doesn't explicitly say that you have to include that information, but this HUD properties rule does. And this rule comes into effect when there's an emergency, such as the COVID-19 pandemic, and determines the extended notice period is necessary to allow tenants more time to access emergency rental assistance. So those are two notice requirements that are very similar and have quite a bit of overlap, but there are some differences. So it's important as a landlord and potentially as a tenant or attorney that you are aware of these notice requirements, and that you figure out whether they apply to your property or not. The other thing, mass ordinances. This is becoming some of these are phasing out. but there are local mask and face covering mandates that are impacting local rental housing. This is the list of the cities at the moment. So some of those are, I know that there's talk in, especially Minneapolis, and to repeal or move back that ordinance or emergency order as things are progressing, similar to the vaccine mandate for like say Minneapolis, that's already been repealed, and so they're talking about that as well. But there are face covering or mask ordinances or emergency ordinances or mandates, whatever the particular city is calling them, that do affect rental housing in Minneapolis, Hopkins, Golden Valley, Duluth, Minnetonka, Rochester, and St. Louis Park. So again, if those are the ones that I'm aware of. And so, yeah, that is it for me. So maybe a little bit longer than the 10 minutes I promised, but not too much farther.
Thank you, Rachel. And I did forget to mention up front that we are really focused on Q&A today. And so we do have some questions that were submitted in advance and a couple in the Q&A Zoom tool, but that's what today is about, is any sort of Q&A in terms of tenant landlord questions, legal questions. We will cover them. So so should we jump over to some of the questions that were submitted in advance?
Yeah, that makes sense.
All right. Maybe I'll ask you this first one, Mike. Lisa asked how to find out who's using the approved paralegal representation program for housing court.
Yeah, so this is a new question. I think it's new. Again, I haven't been involved in these presentations for a while, and those of you that remember me from, I don't know what that was, 6 months ago. Hello again. Nice to see you, or be seen, however to put that. And so maybe this question is asked on a routine basis. I don't know. But the paralegal pilot project is something that's happening in eviction settings throughout Minnesota. It's modeled after a similar program in a couple other states, where the theory is that a paralegal would be qualified to represent somebody in a housing court setting with some limitations and some pretty strict supervision. There is and I just put this in the chat, there is a main page at the state court website, and if you click on the word roster, then it will take you to a link where it will actually list all the places there are approved legal paraprofessionals in the state. And looking at it earlier, maybe there's 20 spots around the state. A lot of them are legal aid type agencies, but some of them appear to be private firms as well. So, and it's not just housing law. I want to say that there's family law as well, that there's some limited cases that the paralegal can work on. The whole overriding goal of this program is to increase the access to justice to folks who are unable to qualify necessarily for full representation from a place like legal aid, and just make it more affordable to get some legal representation in limited type cases where somebody with not necessarily a law degree, but some training could probably capably handle a lot of cases already.
All right. Thank you, Mike.
Sorry, I should have said over and out at the end of that one. It's an abrupt end.
All right. This next one will be for Rachel. Marty asked, does money awarded through Rent Help MN transfer if the tenant moves to a new dwelling?
So I had to go actually out and ask some other folks about this because Homeline is a general rule. It hasn't had too much to do with the ins and outs, nitty gritty of the Rent to Help MN program itself. We are we touch it more through the fact that tenants call us who have also applied through the program or are having some struggles alongside that program application. So I reached out to some folks to get a little bit of a better overview to help answer this question. So there's the tenant. My understanding is the tenant who, when they apply, one of the things that they certify is that the funds are going to be used for the purposes stated in the application. And if the funds are prospective rent, that they have a reasonable expectation that for the months they receive rental assistance, the listed property will be the primary residence. So that's something that, as part of the application, that the tenant essentially promises to. Beyond that, that the tenant, if the tenant does move out while the program has covered that, it's going to be up to the landlord and the tenant to report the move and return the money. So how that works, I have no idea. I don't know who you would contact. I don't know what that would look like or what sort of follow-up happens with that. There's an argument of, when was the money, what was the money intended for, did it go through that purpose? Like, it's going to be fairly context specific, as many things are, of course. So I'm sorry that I can't give a explicit answer one way or the other, but that's the information that I was able to get. I would suggest that if you are a tenant and you are in that situation, that you contact the Housing Justice Center. They've been a presenter here on the webinars before. They were a field partner with the Rent to Help MN program, and so they have a much better understanding of how the application process works and what essentially what happens within the actual program itself.
All right. Thank you, Rachel. Again, folks, submit your questions in the Q&A and we'll get to them throughout our presentation here. And I'm going to jump to this next question. Kim messaged in a question just before our session started. Is there something that shows how much money is left to be distributed by Rent to Help MN? Kim, who's a landlord, says there's several tenants they have who are still in the initial review process, and they're believing they'll have past and future rent paid. But Kim has been told by Rent to Help MN several weeks ago that they were almost out of funding.
That to me?
That's to, yep, sorry, that was to you.
Okay. So my understanding is, this is from some of the things that Commissioner Ho has said to the Minnesota legislature regarding why they chose the 28th of January as the cutoff date. They were, as Kim is implying, concerned about them running out of money and not being able to cover the applications that they were getting. And so they did not want to extend into February and have people apply that they didn't think that they'd be able to cover the rent for. That being said, she was not forthcoming, and I think there's no way that she could know at this point, or as things are getting processed, what how close it's going to be, like, whether they're going to be under or over their estimate. I believe the dashboard that the Minnesota Housing Finance Agency puts up has a pretty decent overview of how much money is spent, how much money is left. It's a little bit slow. I believe when I looked at it today, it was reporting as of February 17th. So obviously a couple days off. They are also, the program is paying out money every day. So it's probably not like supremely accurate. But also at the end of the day, the program was never a guarantee that tenants would get all of their arrears paid, but it's the best option for a lot of tenants and landlords to get paid. And so that's what the purpose of the program. And so I think that was Commissioner Ho's, at least my understanding of what Commissioner Ho has been saying, is that they think they'll be able to pay everything, but it's too close to call at this point, whether that's going to prove true or not.
One is going to Mike. Another follow-up question from Kim. Can you explain to folks that are listening today the difference between non-renewing a lease versus evicting someone? This particular landlord says they've given some non-renewals to tenants, and they're hearing that from the tenants that that was an improper eviction because they have rent help MN applications. So can you maybe just go through a little bit of detail in terms of the difference between a non-renewal notice versus a formal eviction action?
Sure. So yeah, this has been something that we at Homeline ask about when a tenant calls us up and says, I'm being evicted, since before I was working at Homeline, which was in 1996, because that phrase, I'm being evicted, can mean a lot of different things to people, to a tenant. And so what we always do is we try to dig in and figure out what actually is happening here. Is there an eviction? And by an eviction, what I mean as an attorney is there a court case filed against the tenant? An easy way to know the answer to that is there a court date? Has the tenant been served something? And with the availability now to be able to see court databases, it's really easy to tell if somebody has an eviction filed against them or not, as long as they have the proper spelling of their name. But tenants still do believe that an eviction might be a piece of paper given to them by the landlord that says, get out by the end of the month or something like that. And sometimes those pieces of paper will actually say eviction notice at the top, or you're being evicted, even though legally eviction has a definition in Minnesota. That means a court case that landlords spend $300 on roughly. It used to be called unlawful detainers, but that's what an eviction is. As far as what rent help might be telling tenants, hard to know. We don't work at rent help. As Rachel was just pointing out, we know enough to know all the basic framework of rent help and where to send tenants that are having issues with rent help. But all the nuances of what rent help is doing is a little bit beyond us. I can imagine a landlord giving a notice to vacate or a notice of non-renewal, where they're simply saying, hey, this is your notice, leave at the end of next month because your lease is up or you're month to month. And so this is your non-renewal notice. I can see a landlord putting in a notice like that, because we've certainly seen notices like this that say, you know what, you're behind a lot of money, so we're going to give you a notice to vacate, or a non-renewal notice. And the tenant has applied for rent help MN and they have maybe a pending application in place. You have to fast forward a little bit in time in that situation to the tenant not leaving. So let's say the landlord says, get out by the end of February, and the notice was in writing and it was properly timed depending on the kind of lease that the landlord and tenant had. And so on March 1, the tenant doesn't go, and the landlord goes and files an actual eviction at that point. What would a judge do with that notice if it says, get out by the end of February because you haven't paid your rent? Which most landlords don't telegraph things that much, but they might, and they certainly might say it to tenants too. They might have been harassing tenants for months, emails, texts, demanding money, and not getting the money, and finally throwing up their hands and giving a notice to vacate as a way to effectively try to circumvent the protection in place through the end of May of this year. I suppose that's a possible defense for a tenant. That's a longer answer than I think that Kim was looking for, but there's a clear difference between an eviction court case and a notice to vacate / non-renewal from a landlord. Over and out.
All right. Thank you, Mike. And there's another one last one that was sent in advance. David is asking, what is the expected policy on rent control in Minneapolis? And I guess I'm taking that one. So the big difference between Minneapolis and St. Paul on this is that St. Paul enacted through their ballot initiative a very specific policy that that starts on May 1st and is limiting rent increases to no more than 3%. What Minneapolis did was they enacted a ballot initiative that directs the city council and the mayor to look at adopting a policy. And so there's not really a clear answer to David's question here. There is there are some advocates in Minneapolis that are I have identified what they'd like to see a policy be, kind of similar to what I think was enacted in St. Paul. But ultimately, it will be up to the city council and the mayor to proceed with some sort of specific policy. So we don't really have a clear answer about what the expected policy is. There will be discussions and debates on that as the council looks at that over the next year here. All right. Again, feel free to submit your questions via the Q&A system through Zoom, and we'll get to them. I'm going to start taking the ones off the Q&A system here. And so the first one here is from an anonymous attendee. For applicants that requested 1 month advance rent help, so through Rent Help MN, along with any back rent owed, is that being given from the approval date or from the application's original date? Oops. Sorry about that. I hit the wrong mute button.
I was like, do you want me to?
Did you
not?
mute her?
He did.
Apologies. I didn't.
I will.
Sorry.
It's okay. I was like, sorry. My understanding is that it is from the original application date. So if you applied before the cutoff in January, they'd already reduced it down to 1 month future rent before that, I think on like January 11th or something like that. And so if you applied before then, it was for up to 3 months of prospective rent. And then if you applied between, I think, the 11th and the 28th, it was up to 1 month of prospective rent. And so that would just mean February at this point.
Thanks, Rachel, and apologies again for the mute situation there. All right, Emma has a question here. If a landlord erroneously files against a tenant with a tenant who has a pending application, will this still show up on the tenant's record, even if the eviction is overturned?
Sure, and just to give people sort of a heads up on where we are at with questions, we have about 6 questions that are submitted, and we're slated to go till 3 o'clock. So if you've always wanted to ask either an attorney that does landlord-tenant law a question in Minnesota, or an executive director at a place like Homeline, we're all here for your questions today, and we want to make the best use of this time. So please submit whatever questions you have. But not trying to dodge the question that Eric just put in front of me that had been sent in from Emma. Again, if a landlord erroneously files against a tenant with a pending assistance application, will it show up on the tenant's record, even if the eviction is overturned? So this brings us to how evictions mechanically, logistically work. The minute a landlord files an eviction, it becomes a public record. There's some legislation proposed at the state level this year that was also proposed last year that would have some impact on that and limit the effect of an eviction until a decision has been rendered. But as it stands right now, The current law, and the law we've had as far back as I know, is that it's publicly available information the minute the court case is filed. And so a tenant that's dealing with a crisis where they're facing an eviction, they're thinking about trying to find another place, and they go out and apply, and that next landlord says, have you ever been evicted before? Well, you know what, that eviction, again, this is a court case that's filed, will show up on the tenant's background almost certainly, unless and until the case gets expunged. And that's kind of the magic word that we need to have happen if a tenant really wants something removed from their rental history. Expunged or erased, however you want to think about this, is where the court says, you know what, we're in charge of our own records. These are court records. We get to decide what to do with them. And we're going to remove this from our court record database so the world can't see it anymore. Now, there's some precedent for that concept in other areas of the law. For instance, we don't divulge the names of minors frequently in a lot of litigation. There are some what are known as rape shield laws that protect victims' identities as well. In general, though, courts are considered to be open areas. But there has been in the last 15, 20 years, a movement, not just in Minnesota, but elsewhere, to limit the impact of evictions on people's rental histories. It has a tremendous effect when a tenant is applying for a place, especially in any metro area in the state. If a tenant is applying for a rental with a recent eviction on their record, by that I mean within the last few years, it depends where you're at, but 75, 80, 90% of landlords are likely to turn them down without even really considering them past that one question. Is there a recent eviction filed against you? Not did the landlord win the case, was a recent eviction filed against you? So in this case that we're just hearing, where the landlord erroneously filed against a tenant with a pending assistance application, I mean, the landlord didn't erroneously file, they just didn't really adhere to the state session law that's still in place until the end of May this year, where the landlord shouldn't have filed the eviction. I think it should be expunged, but it won't be expunged unless and until the judge rules on that and grants the expungement motion, which I guess the court can do on their own, but probably if they look at the rules as they exist on expungements, the tenant might need to make a motion to ask for that expungement to occur. So unless the tenant makes sure that the case is expunged, I would assume that it's not removed from their record until that happens.
All right, thank you, Mike. And yeah, we have about 6 questions, so feel free to submit them. We will answer your questions until we run out. All right, so an anonymous question. I've been using a screening service through apartments.com. The screening fee is paid for by the tenant directly through the website, and then the report is emailed to me. What is the proper way to handle the screening fee legally if the fee does not get paid to me directly? Does it need to be returned if the applicant is declined?
All right, I'm assuming this one's to me, and I will tell you what I can, Mike might please chime in on this as you see fit. So I'm going to start with the statute. I'm a good little lawyer, and I go, if there's a statute on something, I go to the statute to see what the statute says. And so Minnesota does have a statute regarding applicant screening fees. And what it says about returning an applicant screening fee, there's a couple different scenarios of when a landlord has to return it. So the landlord has to return the screening fee if the applicant is rejected for any reason that isn't listed on the disclosures that a landlord has to give a tenant, but prior to the tenant applying. If a prior applicant is offered the unit and agrees to enter into the rental agreement. And so those are the two big ones. So the landlord has to return any amount of the applicant screening fee that's not used for the purposes of, actually running the screening. So, even if you run the screening and you charge a fee. If the whole amount isn't actually used, then you have to return any overage. That doesn't happen super often, is my understanding. So that's kind of what the statute says about it. As far as how to, get that process through apartments.com or anything like that, that's well outside my wheelhouse of understanding of how to deal with that. But it is the landlord's obligation under Minnesota statute to return it in those circumstances.
And those are limited circumstances where somebody else got approved that was in line before the tenant. I think what the question is really kind of getting to is, what if I turn somebody down? Do I have to give the application fee back? And if it's because the tenant didn't qualify for the rental unit, then the short answer is no, you don't have to return the background fee. Very few landlords ever do that, that we see. If you're going to see a landlord not charging a tenant that, they just don't charge the tenant that, which happens sometimes as an incentive to try to convince tenants to apply for an apartment, depending on the cycle of where we're at in housing. Are there enough empty units or not? As the vacancy rate shifts around, if there's a lot of empty units, the landlord will say something like no application fee, or instead of a 1 month's rent for a deposit, we're going to charge just $300 for a deposit. Those kind of incentives are things that landlords might use. But if a landlord charges the $30 or $50 per adult and turns a tenant down because they didn't pass their screening criteria, general rule is they aren't going to be giving the money back, nor do they have to under the state law.
And is there anything unique in the city of Minneapolis where there is a specific screening criteria ordinance?
Oh, you're talking about the new one versus the old one?
Yeah.
Right. So yeah, and what I meant by the old one is this law that we're talking about, the one that I just posted online, and maybe Eric can post the new one as I'm explaining. The law that we're referencing, the state law, 504B.173. 504B, of course, is the landlord tenant chapter for most state laws on landlord tenant issues in Minnesota. Minneapolis and then St. Paul fairly shortly thereafter had passed screening ordinances in the 2000s, somewhere between 2000 and 2010, I want to say, that the state eventually modeled a state law similarly after. And so those ordinances, I think, are still on the books. We don't really look at them much. I don't think there's much of a difference between those and the state law, at least not a substantial difference. However, Minneapolis does have some new, what they've called tenant protection ordinances that went into place. Wow, was it 2 years ago now? 1 year ago? 2 years ago now, that do limit what a landlord can consider when looking at screening criteria, as far as how far back they can look for evictions. 3 years versus the practical 7-year limit for most evictions, which is what, if you're using something like apartments.com as a landlord, those screening companies are bound by the Fair Credit Reporting Act, a federal law, and they can really only report an eviction for 7 years. In fact, we've had tenants that call us up on our tenant hotline, where we get a lot of calls every year, 15,000 calls a year. They say that they want to get an expungement for an eviction that's 10 years old. And expungements aren't necessarily easy to get. You have to file a motion with the court. There might be a cost involved. And what we would explain to most tenants in that situation is this might not be worth your effort. In fact, it probably isn't worth your time, effort, and money to try to get an expungement for an eviction that's 10 years old, especially if you, but it just doesn't make much sense to bother to do it, because those companies, landlords don't always hire apartments.com, but there's about 10 screening agencies that they seem to use throughout the state, and some aren't based in Minnesota, but most of them are. And so it won't really have that impact on the tenant. But yeah, Minneapolis does have their new screening protection, which limits how far a landlord can look back on the criminal and the credit and the rental context. It also has a limit on income requirements that a landlord might want to use for their screening purposes, and caps security deposits as well, which is the only place in the state that has a law like that.
All right, thanks for the overview of the state law and Minneapolis ordinance. Another question from Emma. What constitutes an adequate pre-eviction notice? For example, if a landlord provides a 30-day notice to vacate that specifically says after this day an eviction will be filed, does that take care of their obligation to provide 7 or 14 days of notice for an eviction? I think
And I think I'm up, Rachel, because I think I just added to your answer last time.
Technically, yes.
So I don't have the power, but I guess I'm sort of muting you just like Eric did earlier. But you'll get the next one. You'll get the next one. Yeah. So yeah, what Emma's asking about, I think, are some of these new city rules that we're seeing here, maybe the CARES Act notice as well. To start, there's no law in Minnesota that blanketly says that a landlord has to warn a tenant that they're going to go file an eviction for non-payment of rent. There was something like that during the eviction moratorium phase out up through middle October of last year. There was a requirement that a landlord give a 15-day notice saying that they're going to go file an eviction if the tenant doesn't pay their rent, with some other stipulations built into it. So what we're left with now is, in general, that's not the law in Minnesota. However, there are a couple places where a notice is still required in order to file an eviction for non-payment of rent. Rachel talked about the CARES Act earlier. That's still in play. It's hard to really understand that that was the goal of the legislation at the time, but that seems to be the accepted outcome of it. The CARES Act, again, was passed in March or April of 2020, right when the pandemic was really just shutting everything down. And Congress passed the CARES Act, which had a lot of provisions to it, not just landlord-tenant stuff. That was a tiny piece of it. That was where the first small business help came, and some of the first individual income supplements came as well. But they did have this provision that said, if a landlord wants to file an eviction for non-payment of rent, they can't do it until July 25th of 2020 or some date like that, I think. It had this provision after that that said, if we get past July 25th and it's still a CARES Act covered building, the landlord has to give a 30-day notice. Now that part of the legislation never, as we say in legislative speak, it never sunsetted. It never ended. And I honestly can't imagine how that could get through the current congressional / presidential gauntlet to get that removed right now. Maybe there'd be some giant negotiation, but it's not really anything that's spoken about that I see. I don't see any news about, hey, we need to repeal the CARES Act provisions from the prominent figures in Washington. So I don't think that's going away. So the 30-day CARES Act notice is still in place. We also have a couple of cities that have decided, you know what, we like this concept of landlords needing to warn a tenant before they file an eviction. So again, we have Minneapolis with a 14-day requirement. St. Louis Park also has a requirement that a landlord gives 7 days notice before they file an eviction. And on those, you really should look at whatever city you're in to make sure, if you're a landlord, that you're complying with what the notice requirements are. From what we understand from both housing court referees and litigants, the courts are requiring this to be done. They understand it, they're following it, they're mandating it, the CARES Act and the city requirements as well. And so I'm not sure if that's really answering the question, but what does answer the question is look at the specific ordinance in each city to see, am I complying as a landlord with what's required to be in that notice?
Right. Next question from anonymous attendee. If a landlord gives a tenant a notice to vacate, but the tenant doesn't leave, and the landlord continues to accept rent checks and is cashing the rent checks, does the original notice go away, or does a new notice need to be given?
I'm assuming this was mine since I'm not being muted by anybody. So if the landlord gives a tenant notice to vacate, but then accepts rent going forward, that notice is considered to be essentially waived. And so that would be, the landlord has accepted the rent, the lease continues on until either a new notice is given or a new agreement is reached.
Right. Let's see here. The next question, is there any more information available about home help MN? Will this be accessible to landlords, or is it solely owner occupied homes?
And although I'm up for this one in order, I honestly had never heard the words home help put together before I saw that question. It's just not the world I work in. I work in landlord tenant stuff. And so home help I wasn't familiar with. But looking briefly at the website, it looks like that's simply for, I think, owner occupied places. Does anybody have any view different than that?
No, it's essentially the rent help version for homeowners.
Okay.
Yeah.
Yeah, we just don't get calls from homeowners. Everybody kind of knows the limits of what we do. And so if a homeowner were to call us up saying, I'm looking for financial assistance to save my home, we'd probably be sending them to a place like the Minnesota Home Ownership Center, which is a wonderful resource for homeowners dealing with all kinds of issues.
All right, thank you. Let's see here. Let's jump to this question here. Hold on a second. So Raina messaged in the chat that in Minneapolis, we have been seeing a lot of larger landlords switching from having tenants pay their own electricity directly to Excel to paying the landlord, who then pays Excel. If a tenant gets behind in electricity, can a landlord charge a late fee, and or could it lead to an eviction for unpaid utilities?
Mike, do you want to take this one since you were rather denied a full question?
Sure. So yeah, first of all, Raina, this is absolutely something we've been seeing an uptick in, is shifting utility responsibilities, along with an increase in, well, I mean, everybody's more worried about this because the numbers are going up, right? People are paying so much more for utilities. We just finished January and we're in February now, which are arguably the worst months of the year for utility costs. And so we're seeing a lot of questions about shared meters, what a landlord can do. To start with, I would say a landlord can't change the rules in the middle of the lease. And most leases in Minnesota, historically, at least a 1-year lease, go from warm weather months to warm weather months. Landlords don't want people moving out in January, February, because nobody wants to move out in January or February. So the landlord knows it's going to be harder to re-rent the place those months. So most landlords try to direct leases to end between April and October. And so a landlord trying to shift the utility system in place, how payments being required under the contract, can't simply change it in the middle of the lease. They'd have to wait until the lease ends. There is a shared meter statute, if there's a shared meter situation in the building, that is a state law that the landlord would have to comply with. It's not that hard to comply with, but it does require sort of a checklist of things that a landlord has to do in order to go with a shared meter system. Now, the bigger question, can a landlord file an eviction if the tenant doesn't pay the utilities that are owed through the landlord to the utility company? It would depend on the lease, but probably is going to be the short answer. Would a landlord do that? Probably not for a month or two, but if it gets to be several months, they might decide it's worth it at that point to try to charge the tenant for, try to file the eviction for that reason. Again, evictions aren't free, they're $300. We don't see a lot of evictions filed because a tenant didn't pay their electric bill for a month or two, or their gas bill for a month or two. They're just not filed frequently. A more likely court approach might be for the landlord to try to keep it out of the tenant's security deposit when the tenant vacates. And I noticed that Eric just posted the shared meter statute as well, which is again found in chapter 504B. If you're looking for answers to landlord tenant legal questions, it's a great place to start.
I'll plug in just as a thought for any landlords on the line that there are assistance programs that exist out there for the bill payers who are behind on the bills. And so while a tenant may be able to get that for themselves, like to get the bill, to keep the lights on and keep the bills paid, I imagine that if you are the sole bill payer for the entire building, it gets to be a little bit more complicated getting that access to that sort of assistance.
Right. Thanks to both of you there. We got a little over a half an hour left here. We have 7 questions in the queue. Again, if you have a question, feel free to submit it. We'll definitely be getting to all of these questions. All right, so the next one is from Lisa. Is there an alternate way to find out the status of a rent help MN application for a tenant who applied right before the deadline, which was January 28th? Logging into the site leads to a notice saying the applications are closed and the tenant has received no updates at this point.
Short answer would be probably to call 211 to get a status update. My understanding is that if the tenant hit the submit button, then it should be at least submitted, and the application is probably under initial review if it hasn't been moved from that yet. But there are several, I guess, submit buttons. I think there's 2 from what I understand. So there might be some confusion as to whether the appropriate submit button was checked or not. So I think starting by calling 211 is a good place to go if you can't get the update through the online portal.
Thank you, Rachel. And then I'm going to jump back to Emma's question. She asked a question earlier about pre-eviction notice. So I asked earlier about what constitutes the pre-eviction notice. To clarify my question, I'm wondering if simply including language in a notice to vacate stating an eviction will be filed if you don't vacate would constitute the 7 or 14-day pre-eviction notice in the relevant cities, or if the landlord would need to provide a separate notice that an eviction will be filed.
I think there's some other requirements. I don't have the ordinances in front of me, and I look at them whenever I get a case that comes in front of me. But unlike some of the actual laws the state laws that I've been talking about today, I don't really have decades of experience with them. So I don't have them, like I said, top of my head. But I think they require a statement about how much is owed as well. And so a generic notice, you're late on rent, pay up in 7 or 14 days might not be enough in either one of those 2 cities. And I don't know if Eric is pulling one of them up or not right now.
And I think part of the clarification is that just giving a notice to vacate, if there's those notices are only required in non-payment evictions. So if you're just telling the tenant you don't want to renew the lease anymore and that they want to get out, then that would probably not be, from what it sounds like, a non-payment eviction.
Yeah, and I did a little bit earlier, I did put links to both the St. Louis Park and Minneapolis ordinances. If you bring up the Minneapolis ordinance, it does have a very specific, it has some very specific things that you need to put in the notice in terms of the total amount due, an accounting of the amount that's due, and then the person who is supposed to be paid. So again, these are outlined in city ordinance and set up requirement for how they work. Okay, let's see here. Let's jump to this anonymous question. Is having a security camera system on the exterior of a home set up by the landlord a privacy concern for tenants, specifically cameras near the tenant's main entrances to the home?
Most of the time, if the landlord and property owner decides they want to put security cameras up on the outside of the premises, then they are within their rights to do so. So long as they're not like pointing into the the actual like, space that the tenant has the right to possess, so like inside the windows or anything like that. You know, whether you pointing it directly at the front door, again, that gets to be a little bit more of a gray area, but depending on how far inside it can view and things like that. But at its baseline, you know, if it's the property owner wants to put security cameras up on the outside or in the common areas of the property, they're probably within their rights to do that.
All right, thanks, Rachel. Then there's a comment by somebody here, not a question per se, but what they're stating is that not accepting housing vouchers should be considered a violation of fair housing laws, as it is often federal funds. Landlords shouldn't be able to increase rent if that ever changes.
Yeah, I mean, I get the argument that somebody's making here for sure. And Minneapolis has the first in the state, landlords can't discriminate against tenants for having a Section 8 voucher ordinance that is still winding its way through courts, although the state Supreme Court ruled favorably for Minneapolis on that, wow, a year, 2 years ago. I don't remember when it happened, but it's been a while. Anyhow, I can't guarantee that it is as an attorney might say, an actionable claim anywhere else in the state to say that a landlord turning down somebody for a voucher. There was a Court of Appeals case that went to the State Court of Appeals, 2010, 2012, somewhere in there, that was the challenge, is whether or not a landlord could effectively discriminate against people who held Section 8 vouchers. And the Court of Appeals, the Minnesota Court of Appeals, said more or less yes, because it was sold as a voluntary program in the 1970s, and there were some other complicated arguments as well. I didn't agree with the Court of Appeals decision, but you know, it's just the State Court of Appeals, and it wasn't appealed to the state Supreme Court, so we never got that decision on it. But we're not going to argue with that concept that landlords shouldn't be able to discriminate based on somebody holding a Section 8 voucher, but courts have to agree to have any kind of real meaning there.
Right. Thanks, Mike. All right, moving on. We have a landlord from an anonymous attendee saying, we have a landlord that we believe is targeting tenants who are Native American and or people of color. 15 notices to vacate in the last couple of months. They don't provide any reason as to why they are being asked to leave. Many of the tenants are part of the group residential housing program and work through one specific housing agency. What steps do you suggest these tenants take? Should they work as a group or individually?
I think this one's, I'm on deck. So first off, if there's any claim or thought that there's discriminatory housing practices happening, we recommend filing a complaint with the Minnesota Department of Human Rights. They have a very easy complaint form to use, or with the city, depending on what city. Some cities have their own departments. I believe Minneapolis does, and St. Paul, I believe, does as well. That might have a faster turnaround time than the state does. But whether to work as a group or individually, I think filing individual complaints is not a bad idea, because the more a lot of the state agencies work on volume, and so the more complaints they get, the more it kind of rises to the top. In general, a landlord, if the lease is coming to an end, to its natural conclusion, doesn't have to have a reason under Minnesota law to end the lease. Minnesota doesn't have any just cause requirements, as what the term is. And so if the landlord doesn't give a reason, they don't have to, if they just remain silent. That doesn't preclude the tenant from saying that something is discriminatory or not. It just requires then other outside evidence to show that the non-renewal was a discriminatory action. And so that it's complicated. There St. Paul briefly had a just cause essentially requirement in their city ordinance before they repealed it, but that's as close as anywhere in Minnesota has gotten so far to having any sort of any sort of requirement on landlords to have a reason to end a lease or not.
Here. Okay, question from Sam. Sounds like a landlord here. Sam has a tenant who's on a month-to-month lease who moved in November of 2021. The tenant applied for rent help MN. Rent help MN approved to pay from November 2021 through March of 2022. And this and Sam is asking, what is the proper way to evict this tenant who cannot afford the rent?
So I guess to start, my first reaction is we're not really sure that the tenant can't afford the rent going forward. Maybe they've gotten a new income source, maybe it's a new job, whatever. So as of March 2022, they're going to be on their feet and able to afford the rent. So I wouldn't necessarily assume that. I don't know that there's any real harm in asking the tenant, hey, this is paid up through the end of March. What do you have in mind after that? Did you want to stay? Do you want to go? What are your goals? I think opening those lines of communication with the tenant and then give them a chance to say, yeah, I can afford it. Things have turned around. Ran into a hiccup back in November because everything shut down again briefly. And in my line of work, it sent me reeling, whatever. There are conceivable stories where somebody not able to pay in November through March will be able to pay going forward in April. So I wouldn't assume the tenant can't make this work financially. As far as the proper way to evict, again, this is one of those situations where evicting and a notice of non-renewal aren't the same thing. A notice of non-renewal is simply where the landlord says, you know what, our lease is over or you're month to month, so I'm not going to renew this as of the end of next month. And so that would be how a landlord would consider going at this, is if you decide that you don't want to renew the tenant's lease, you give them the proper written notice under the lease. It's got to be written and it's got to be properly timed. But again, I would talk to the tenant and see if they think that they can going forward maintain the place, and might be better for everybody.
Right. Thanks. Thank you, Mike. Again, it's just about 2:40. We got 20 minutes left here and still have about 5 questions. So we'll get through these, but if you have a question, please feel free to send it over the Q&A system. All right, we're going to jump to this next question from an anonymous attendee. Hold on. Okay. How to encourage people to obtain screening documents, appeal denials, file expungement, fight evictions, or not accepting poor rental conditions and so on when people are experiencing homelessness and who are very low income. It is difficult because people are trying to survive. I can advocate help where I can, and I suggest they do, but I cannot offer legal advice. And so this person is talking about some maybe clients who have limited resources and don't have a lot of time or energy to try to fight some of these issues that were brought up. Any alternatives or suggestions?
Well, for one, I hear you. Like generally folks who are in these situations there's a lot going on. There's trauma, there's just a lot of stress. So it's hard to have the energy to do all of the things that need to get done, or we think that need to get done. First and foremost, I would say if they're a tenant and they're looking for legal advice under landlord tenant law, give us a call. We offer free advice. We don't offer representation, but we do offer advice, and at least often some suggestions of what tenants can do going forward. As far as things like evictions and self-advocating, depends on where you're at as a tenant. Legal aid is a great resource right now for evictions. They offer, if you're low income, they offer free representation, and they're focusing right now on evictions. I know there are other resources out there that are focusing on assisting with like expungements and things like that. So those situations, there are legal options and representation out there for tenants who may be experiencing this, so that they don't have to push their own way forward. Beyond that, I mean, that's one of the reasons that I think, and Eric can correct me if I'm wrong, but one of the reasons that Homeline also, pushes things at the state policy level is because there are a lot of these things that just, it's a traumatic, stressful experience. And, so trying to make sure that things happen or don't happen, so that, someone who may be out of a job and stressed about trying to pay their rent also doesn't then have homelessness on top of their stress levels.
And the first part of that question is about how to encourage people to obtain screening documents. So when a tenant applies for a place, the landlord never wants to be surprised by what they find. That's a bad sign. If the landlord does the background check and they gasp because they had done their pre-screening questions with the tenant and it hadn't been disclosed information on there, the tenant's virtually guaranteed to not get that place at that time. And so if a tenant has been denied, and if they've been denied within 60 days, they can go back to that landlord and say, hey, you denied me. Which screening company did you use? And the landlord has to tell them. The screening company has to provide, if it's within 60 days, a free copy of that screening report to the tenant. They might require the tenant to prove who they are with some form of ID, but it's really worth it for a tenant to do this, because they'll know what the next landlord is probably seeing. And once they know that, they can minimize the impact as much as possible. I'm not saying that they're going to get a place, but, and I've seen tenants actually do this, where they'll show a recent background check that was done to the next landlord and say, hey, you know what? This is what you're going to find. Do I still have a shot at the place if this is all you find? And the landlord might ask some clarifying questions at that point. Oh, you had an eviction from 4 years ago. Well, did you ever settle up with that landlord? Yeah, that's why you're going to see that my credit doesn't show anything about me owing the landlord. But yeah, you can contact the old landlord. And the landlord might say at that point, well, you know what, if that's all I find, then okay, the place is yours. When I run the background check, nothing new shows up. So I really think that's worth the effort for a tenant looking for new housing, if they've been denied, to find out. And it's really important if somebody has a common name. And that can mean a lot of different things from a lot of different cultures, but a common name usually leads to mistakes, whether it's in the eviction world or criminal record, or especially credit, where some of these reports will say possibles. I've dealt with tenants that have had evictions filed against them in other states according to these reports, and they've never lived anywhere else but in one county in Minnesota. And so they can present that information to that next landlord. I don't know who that person is. It isn't me. I can show you an ID from that time or an old lease. I didn't live there. So there are things that make it worthwhile to look at that old screening report. And so I really encourage tenants to do that when they've been turned down.
One other thing I'll add as well is that, especially for like poor rental conditions, if it's a multi-unit complex, one tenant is probably not the only one experiencing those issues. And so having many voices is much harder to ignore than one single voice. So organizing, getting together, having a group of tenants advocating for the group for one thing or a couple things. That way the stress level is also on one individual person is minimized, but it's also more likely to have a result.
Right. Thanks for the answers to that inquiry. A few more that have come in. Okay, so Pat is asking, can a landlord or management company charge a move-out fee of $300 when a tenant ends their lease?
Well, I tell you what, they sure do. Can a landlord do that? It depends on how the lease is written is the short answer. If it's clumsily done where the landlord is keeping it out of the security deposit automatically, I would say the landlord has a problem potentially by trying to dodge the security deposit statute. But if it's done right, yeah, I think a landlord can do this. I think a landlord can charge a $300 move out fee. They charge $300 move in fees. We're in the fee era right now. I don't even think we understand how deep the pool is, even though we talk to so many people every year. But once a month on our tenant hotline, where we get somewhere between 1,000 and 2,000 calls, we're going to hear about a new fee that none of us have ever heard of before. These are fees that aren't optional. I'm not talking about where a tenant says, "Hey, I want to get the garage spot, so can I pay extra because I want to have that garage spot in the winter, or I want to have a pet, and so I'll pay your dog fee or your cat fee." I'm not talking about optional fees. I'm talking about required fees. These are popping up everywhere right now. Landlords are in serious competition with airlines for creative ways they can tack fees on to leases. And the problem that I have with this is that tenants don't really know what they're paying. If you look at a Craigslist ad or something that's maybe on Housing Link, or even a sign stuck in the yard, it's going to say rent $1,500 per month. Okay, so you know what the rent is, right? And then you get to signing the lease after you've applied, you've done the tour, spent some time and effort, and maybe most importantly for a lot of tenants, hope. Hey, I think this is the one for us. You start building towards that place. And then the landlord springs the lease on you with all these fees that weren't disclosed in the ad. And the problem is it isn't really showing how much the rent is. There's actually a new movement by landlords. This is pretty much new this calendar year, where we're seeing landlords charge a monthly administrative fee. Now, it's not a lot. It's 7 or 10 or 20 bucks, but why isn't that just part of the rent? It doesn't make any sense to me that it isn't part of the rent. The only reason I can think of for a landlord to do that is because they want to keep the rent number lower. So when somebody's doing a search, I want to look for a rental unit in either Minneapolis or St. Paul that's in the $1,200 to $1,400 range on Craigslist, right? You can do that. You can do those narrow targeted searches, and a place for $13.99 will show up, and then you get there and there's $50 more a month in fees, and you've planned for a budget of what you've planned for. Once again, this is something that there's legislative efforts at the state level to try to address, but as an industry, we need to address this quickly because it's becoming, I don't know why there's not a mortgage fee. Help me pay my mortgage fee. There's a problem probably with doing a maintenance fee, but I don't know why landlords can't charge fees based on their favorite astrological sign. Anything, based on, hey, the NFL season just started, so there's our NFL season fee that we're going to charge you. They don't have to justify it. They can just say it's part of the contract. And I'm not being facetious. They can add that fee in for any reason they like. And that's okay. Landlords get to charge what they get to charge, but it should just be called rent. So, Pat, I hear your question. It increasingly bothers me as somebody who works on behalf of renters and, on a broader sense, consumers, to see this, I think, deceptive sort of trade practice that landlords engage in, where they don't name every fee in their total overall price. Sorry to get fired up. Wow.
No, thank you for discussing fees. All right, let's see here. An anonymous question, and it sounds like this is coming from a landlord's perspective. Can I block off certain sections of the exterior of my property during specific periods of time during the year? The reason for this is I have a duplex with paved walkway on the side of the house. It gets very icy during the winter season and would like to have it open seasonally if possible between April through October during non-winter months for safety reasons. And in this example, all the units would still have access to two front and rear entrances and exits. Oh, can I block off certain sections of the exterior of a property?
So my initial reaction is it depends, but is blocking it off going to do what you need it to do? Also, in general, under a lease, if the landlord gives access to a space like laundry or a basement or something like that, and then tries to restrict access to that, then the tenant should be compensated in some way, generally by a reduction in rent. Now, outside walkway is not a laundry room, I'll admit that. And so, but is it safety? Obviously, it sounds like it's safety concerns, but why aren't you just salting it, or why aren't you, say, compensating one of the tenants if you're not living on site to go out and sand the space when it gets icy or something like that? Is the blocking it off the only option? And if it is, then that should be something that's written into the leases to just make it very clear that the space isn't available during the winter months when it's icy or something like that.
All right, thank you, Rachel. All right, there's a question here from Carmen. Is there any part of landlord-tenant law that would help with a criminal matter other than conciliation court and pursuing a judgment? It sounds like a landlord is saying a tenant moved out with their lease non-renewal. There was the landlord inspected, there was a lot of damage and items left in the home. The tenant called to say that they were going to come pick some of the stuff up, and there was instruction given to meet at the property. The landlord is saying the tenant broke in and then caused some damage to the furnace. All the pipes froze, estimates of over $65,000 in damage. So security deposit is one thing you can take there, but what else can a landlord do in a situation like that where they are alleging that the tenant has caused damage?
Okay, let's kind of take this step by step. The first thing a landlord should do is send the tenant a letter saying what happened to the deposit within the 21-day limit. That's what the landlord needs to do as best you can. And it should be based on receipts if possible, estimates if it's not possible to do that within the 21 days. The 21 day starts when the tenancy ends and when the tenant provides a forwarding address of some type where they can tell you where to send the deposit to. Doesn't necessarily have to be where they live, but some sort of mailing address. As far as criminal charges, I don't know if there's criminal charges really here or not. You'd have to talk to the police / county or district attorney to figure out if they think that there are crimes that were violated. They decide that. It's one of those things that you learn in law school that they wish that they wouldn't show on police dramas, the concept of pressing charges. The state decides whether to press charges. It's not the victims necessarily, rarely is, where they get to decide that the police go forward with the case. The police and the prosecutor decide if they want to go forward with the case. And so they look at that and decide if that's something they want to do, if they think a crime was committed here. Can you sue the tenant for money beyond the deposit? Sure. It's not going to be conciliation, as I mentioned a couple times in the question. Conciliation court is capped in Minnesota at $15,000. So that's a high number, actually. There's a couple states in the country that have more, but we're certainly in the top 10 states for how much you can sue for in small claims or conciliation court, which only costs $70 to file and no attorneys required. So that's a kind of a nice court to start in. But if you wanted to go there, you'd have to lower your claim to $15,000. Not sure if there's insurance in this situation or not. I'm assuming that you've looked into that as the owner of the property as well. But you could sue in district court, which is the next level up. Those cases aren't as easy. Much harder to do without an attorney, frankly. They can be done without an attorney, but they're not simple. And the court will hold you to a much higher standard. They're going to expect that you present a case like a lawyer would, whereas in small claims court, it's very similar to what you see on TV, Judge Judy or the people's courts of the world, where you present your information to the judge in a 5 or 10-minute hearing. District court is much more complicated and procedurally complex, but you can sue for a gazillion dollars there. There's no cap. Will you ever collect the money is another question. Maybe. I think that if you actually won a $65,000 judgment against a tenant, there's a real chance that they'd be looking into filing for bankruptcy at that point. And so I'm not sure that there'd ever be any money available at the end of that litigation rainbow. So I'm sorry I'm not giving you great news, but those are just sort of the options that jump to mind.
All right, thanks, Mike. And we're gonna jump to this other question that's related to security deposits. What should a tenant do when they've given proper notice, vacated the unit, their apartment is clean other than normal wear and tear, and they don't get their damage deposit back?
So they can sue in conciliation court, is the short answer to that. There are specific guidelines as to how much they can sue for. There's also a bad faith penalty if the landlord just knows that they're supposed to return it and they don't. It's presumed that they do know. So that is the short answer, is you can sue them in conciliation court for it.
A slightly longer answer is the tenant should contact us. We get it's the second or third most common reason people call us on our tenant hotline, because there are generalities that we can give, but it's all about some details in those situations. And so, is suing the best move for a tenant? How to do it? We can walk them through all those parts. Yeah.
Somebody asked in the chat about the link for the HUD notice requiring a 30-day notice. I'll put that in the chat in just a moment here.
They mean the CARES Act? Is that what they're?
It might be the more recent.
It's the more recent one, I think.
October 7th notice, and I've got it in. I'll put it in the chat in just a moment.
Okay.
Okay, so let's jump to this question that Alyssa sent in. How do you prove an action is discrimination? I understand that it is showing person was treated differently by the landlord than a person under similar circumstances. Any examples of discrimination cases that were in the tenant's favor?
Yeah, I mean, you can Google it up and you'll find cases. I've had the opportunity to give a lot of speeches to landlords around the state. I can't remember, over 100, maybe 200 now speeches that I've given to landlords throughout the state. And I'll tell you what they fear as landlords is a situation like we heard about earlier. The tenant leaves in the winter and then the pipes burst. That's one fear they have. But another big fear they have is discrimination suits, which aren't as common as one might think. But when they happen, it can be a lot of money. So winning discrimination cases tend to look at in two different ways. One is the landlord turning somebody down, so denying housing to somebody, which can be harder to prove. But in general, what's used for that sort of thing is testers, where enough complaints are given about a specific landlord and their screening practices, and they think that they're being discriminated against based on a protected class status. And then testers are sent out with different protected class statuses to see how they're treated. And if there's enough evidence, then there might be a case against the landlord. But we also see stuff where tenants are in a place and landlords will, or their caretaker or their superintendent will be throwing racist language around at tenants. And one thing I tell every landlord group that I'm ever in front of is you should assume you're being recorded all the time, because in our modern world, it ain't hard to do. And it's perfectly legal for somebody to record a conversation they're having with you, and they can use it against you later on. So that kind of evidence can be really powerful against a landlord. Sexual harassment is a form of discrimination that a tenant can sue for. Over the years, we've had not a lot of volume of those calls, but when we do get calls from people, it's surprising sometimes how landlords will text their sexual harassment to a tenant, which is just sort of mind-blowingly, well, it's evil, but it's just stupid to have that kind of trail of doing that. Clearly, that landlord doesn't think they're doing anything that's wrong or illegal, or else they don't think that anything is going to come of it. And so there are cases where landlords will just do discriminatory stuff that's recordable, But when it comes to the screening, which is harder to put a finger on, there are ways still where it can be determined.
All right, there's one last comment in the Q&A, an anonymous comment that was building on a previous comment. This person is saying they've heard many landlords state they will work with housing support, so group residential housing, GRH, I believe, but they'll not work with a particular agency that administers it. So for example, they'll work with Simpson, but not St. Stephen's. Has this been litigated before? Does it seem like something that should be challenged or left alone? And this person is saying that often the clients don't have time or energy to push past the original denial up front. I'm not sure that's a question, or I guess it is a question. Any thoughts?
I'll say this is really hard work. People that do things like rapid rehousing work, trying to find a place for people that are coming out of places like shelters or they're homeless, hard work to do, and it's a lot about relationships. And so the folks that are really skilled at this build relationships with landlords over time, and there's a trust level. And I don't know if there's an actionable claim there or not. I haven't seen one taken where a landlord says, I'll work with this agency, but not that agency. But like I say, I can guess as to why the landlord is deciding to go that route, because they had a bad experience or experiences with people placed by one agency and not by another. And that's unfortunate, but again, I'm not sure that there is a claim there. I don't know. I haven't seen one before.
Okay, well, thank you. I think we got through all the questions. Nice job. Thank you, Mike and Rachel.
Well, thank you to those watching that submitted all the, we had 3 questions at the start of this, and people just kept pouring in with interesting thoughts and questions. That was great.
Indeed.
Yeah, appreciate your participation today. Like I mentioned earlier, we do not have our March date set up, but we will be planning to continue this series on a general month-by-month basis with some additional topics. And so you'll get an email with information about when we do schedule the next couple seminars. But again, thank you today for participating and sending in your questions. And with that, I will end the session. Thank you, everybody. Bye-bye.